Good evening, dear colleagues. I suggest to start our seminar today. First of all, thank you to everyone who came today, despite this very Russian winter, true winter. So true that I think even we who are from Moscow are a little bit surprised. So the traffic jams are awful, and unfortunately we don't have all the participants that were registered for this event today. It was more than 60 people, but still many thanks to those who came today. I hope that one of our next events will be already in spring or in summer, and in this case more people will come, maybe even not by car, and in this case in order to attract more participants and to attract you too, I would announce that in summer and in spring we will have coffee breaks outside this beautiful inside garden. So today we could do it, but we should provide them special, I think, Valenki. Yeah, so it will be a kind of another type of party. But today we met in order to have our seminar on a very interesting topic, which is called the role of procedural soft law in international arbitration. I would like first of all to announce our speakers today. Many thanks to the speakers, because we have all the speakers today who came to this event, and moreover we have speakers who came from not Moscow, not Russia even, but from far away. And I'm very happy to announce speakers. I will start from left to the right. Diego Gosis, partner at GST, Miami, USA. Oh, Nikita, excuse me, I haven't seen you. Okay, but okay, I'll still start with the most far away city, I think Miami, that we have today from Diego. So I suggest, thanks for coming. Okay, excuse me, Nikita. Nikita came from Hamburg. Nikita Kondrashov, who is associate at Luther Rechtsanwaltsgesellschaft RmbH, speaker from Germany. Then we have Eleni Polikarpou, who came from London, from Withers Worldwide law firm. Eleni is partner and co-head of international arbitration practice. On the left from me we have Artem Doudko, who came from London too, and Artem is a partner at Osborne Clarke law firm. On the right hand side from me we have Olga Tsvetkova, who is senior associate at Yegorov, Puginsky, Afanasyev and Partners, who is also the co-chair of our young IMA initiative, new young initiative of Institute of Modern Arbitration. And the last but not least, from Paris, from France, who Paris also experiences now snowstorms with 4 centimeters of snow, which is a huge disaster there. Sergey Alekhin, who still came here from France, associate at Willkie, Farr and Gallagher LLP, who is also one of the co-chairs of our young IMA initiative. Thank you very much, dear speakers. As I told before, we have a very interesting topic that is dedicated to soft law. For I think last year, and for not only last year, but for a few years, we were discussing, I think, hard law, and we were discussing arbitration rules. We were discussing all those more obligatory regulations in arbitration, and now I think it's a good time to start discussing soft law. However, soft law is, although someone thinks that it's very positive institute, and it helps arbitration a lot. Still, there are a lot of things to discuss because there are some critics in regard of some soft law regulations. It's not only the best practice, but for example, something that some soft law regulations doesn't take into account the difference between the common law jurisdictions and civil law jurisdictions. So that's why that's very good that we have here representatives both from common law jurisdictions and from civil law jurisdictions. I think that we will discuss this issue in particular. It will be very interesting. Some people think, for example, I was reading some articles about soft law before this seminar, and some authors say that soft law helps to find the right equilibrium between fairness and efficiency. But on the other hand, some authors think that soft law is also a part of largely discussed now so-called judicialization of arbitration, yes, which is criticized, and so making arbitration more complex, more regulated, going away from traditional and fundamental notion of arbitration like a very dispositive instrument and method for dispute resolution. But in my opinion, like in all difficult things, and arbitration is rather difficult now, devil is in details, and so that's the goal of our today's seminar, and I encourage, first of all, very live discussion because we have modern arbitration live format. I encourage the participants of the seminar to ask questions to the speakers during the discussion. All speakers to comment on each topic, on each issue, because we decided to discuss to make the structure of this discussion today on the basis of different documents that refer to soft law, that have soft law regulation in them. And so we will start with one of the most, I think, popular soft law instruments, documents, which is IBA guidelines on conflict of interest. And I would like at first to give floor to Sergey Alekhin, who will provide some, I think, brief outline about these guidelines, and also share his thoughts, what shall be improved, what are the advantages of these rules, why they are so popular, why they are used, what is the criticism in regard of these rules, and what are maybe some perspectives to reform these guidelines.
It's quite an ambitious introduction, for which I thank you. I will do my best. Well, I thought I'd start with a general introduction in case, some of you might have forgotten how are these structured, these IBA guidelines on conflict of interest, what are they there and what do they do? So 2004 is the first edition, 2014 is the second edition. The international community and the IBA specifically realized that something must be done, preferably with conflicts of interest. The requirements of independence and impartiality obviously being internationally recognized and found in every institutional rule. The rules would require the arbitrators to disclose, as a general phrase, all the facts that could reasonably be considered grounds for disqualifications. Now, to combat conflicts of interest, a number of efforts have been undertaken, including the IBA, which published or which produced the IBA guidelines on conflicts of interest. Of course, there are other guidelines such as the AAA or the ABA Code of Ethics. Since we're in Russia, I think Olga will be speaking briefly about the ICAC rules. They're not guidelines, they're rules now, on conflict of interest. Let's call them rules. So IBA guidelines would be one of those soft law instruments, perhaps the most known, the most recognized, maybe the most used. It could not be not said that the guidelines did not have any significant impact or that they're just there as a piece of paper. IBA is, of course, an authoritative institution that produces, one would think, well thought and elaborate documents. So they did have practical significance and use, of course, in international arbitration. A lot of articles and books was published on this, and I will not bore you with statistics. So structurally, you have, of course, the general standards and then the set of practical applications or lists. In a very user-friendly way, they're color-coded. You have the red, orange, and the green lists, which is, again, quite user-friendly and perhaps was intended to sort of, make this a bit more easier to use. The subjective test, the objective test, which I really do not think I should get in detail about, as this is quite well known, but briefly, the so-called subjective test that's general standard 2A, would provide that an arbitrator shall decline to accept an appointment or refuse to continue act as an arbitrator if he or she has any doubt as to his or her ability to be impartial or independent. That's the subjective test. The objective test, general standard 2B, being that an arbitrator shall decline to accept an appointment or refuse to continue act as an arbitrator if facts or circumstances exist which, from the point of view of a reasonable third person, having knowledge of such information, would give rise to justifiable doubts as to the arbitrator's impartiality and independence. Just a few words on the characteristics of the IBA guidelines, which I think are applicable to any soft law instrument. The guidelines, nor the rules of ethics that still exist, that were there prior to the guidelines, have independent legal effect of any sort. They're not adopted officially by any leading arbitral institution, either as binding institutional rules or advisory guidelines. To some extent, that's debatable, but they're not binding in effect. And therefore, they would not apply as binding legal rules in institutional arbitrations, one would think. And the basic legal character of the guidelines and the rules of ethics that existed before that is, at best, I would say equivocal, simply because the provisions do not have independent legal force or contractual effect, but nonetheless, they purport to state prescriptive rules that putatively regulate the conduct of arbitrators and parties, and that are apparently relevant in proceedings before both the appointing authorities and national courts. And just by way of example, unlike the IBA rules on taking of evidence, which we will be talking about later on, it's quite evident, but curious nevertheless, that the guidelines rarely, if at all, are incorporated into arbitration agreements per se. If parties do sometime make reference to the IBA rules on taking of evidence, simply because it is again, very user-friendly and default by some accounts method of producing evidence, document production, etc. The IBA guidelines are, well, at least I haven't seen an arbitration agreement. I'm not saying that it doesn't exist, where the guidelines would be referenced. Still, the guidelines were the product and are the product of a working group of 19 experienced international arbitration practitioners and arbitrators drawn from every major legal system. They were recently revised in 2014. One would say the revisions are incremental, but I would suggest that it being the IBA, you would not expect anything radical or revolutionary from an updated document. So the updates simply reflect how the arbitration world and legal practice overall developed in the past 10 years. For instance, by a polite reference to third-party funding, which I'll mention later on, the guidelines drafters cited what they described as a trend towards more disclosures and more opportunities to use challenges to delay arbitrations or to deny the opposing party the arbitrator of its choice, resulting in frequent objections, challenges, and withdrawal or removal of the arbitrator. So you would think that the IBA guidelines were there to somehow structure and limit those guerrilla tactics of some sort, or to structure somehow those challenges to the arbitrators. This not really what has happened, and I'll deal with this, but a couple more points before that. Fundamentally, the guidelines define the general principle of their existence as follows. Every arbitrator shall be impartial and independent of the parties at the time of accepting an appointment and shall remain so during the entire arbitration proceeding until the final award has been rendered or the proceeding has otherwise finally terminated. But there's no positive answer to the question what an arbitrator must do to comply with the standard. The content of the arbitrator's duties under the IBA guidelines has to be inferred from the negative standards formulated in respect of the arbitrator's duty to reject an appointment if there's a conflict, either in the general guidelines or in the 3 lists. Well, not the green list, but 2 lists. The guidelines would then prescribe that an arbitrator is obliged to decline an appointment or withdraw from arbitration in case he or she is unable to be impartial or independent, or in case of an actual bias. But any doubts as to the ability to be impartial and independent should also lead the arbitrator to decline his or her appointment. All this to say that the application of the standard recorded in the IBA guidelines involves quite a lot of elements of subjective appreciation. And one would say that that was the intention, that's the only way to approach this issue. But still, which doubts are reasonable and justifiable in the framework of the relevant facts? Which are the relevant facts? What does a reasonable third party think? Who is that reasonable party? Whether it should be someone, let's say, local or from a third party jurisdiction. So all those issues, or questions rather, point to the subjective nature of the very debate that surrounds the IBA guidelines. How is it perceived in arbitration practice? Well, that's actually rather interesting question. So 2 points here, institutional and national courts. Institutionally, a number of arbitral institutions, initially when the guidelines were published in 2004, greeted the IBA guidelines with considerable coolness, if I may say so, referencing the Moscow weather and the Paris weather recently. Mostly because of the concern that they would become basis for seeking judicial review of institutional decisions on challenges on the or for subsequent annulment of the awards. ICC stated publicly, repeatedly, to the best of my knowledge, that it would not apply the IBA guidelines or other guidelines in considering institutional challenge officially. LCA also indicated skepticism about the guidelines' usefulness in institutional challenges. However, both the SCC, Stockholm, and WIPO have stated that they do take the IBA guidelines into account in their decision-making on challenges, which I think is an interesting development. PCA, acting as an appointed authority, frequently does cite the guidelines in its decisions whenever they're public. So ICSID is actually quite interesting as well, because ICSID would have, of course, its own standards of its own understanding of what impartiality and independence is. But since the default rule is that the application with respect to problematic arbitrator would be decided by the 2 arbitrators. The fellow arbitrators, that is. If you read the decisions on challenge, frequently the IBA guidelines are cited. They would say that they're not bound by them, of course, but still they are referred to in ICSID jurisprudence. And coming back to the ICC, one interesting point that I recently read. So ICC made clear, again, expressly in writing, that when an arbitrator's confirmation is subject to an objection, or when an arbitrator is challenged, and referenced by the Secretariat of the ICC Court of Arbitration to an article in the guidelines does not bind the court and does not mean that court is applying the guidelines, which to me is quite characteristic. So the ICC would say, well, we don't really care about the guidelines, nor do we recognize them, but even if we cite them, please don't cite us on that, because it's just because of convenience or because the parties referred to them, assuming they were the parties, which to me is quite telling. But anyhow, national courts, well, here the references to the guidelines range from inapplicable, case in Austria, for example, to the best of my knowledge in several cases, to no independent status, but the courts will take them into account, as in Switzerland, for instance, in France. U.S. courts, again, to the best of my understanding and knowledge, have referred to the IBA guidelines in the annulment proceedings, or set-aside proceedings after. A recent, fresh example from Colombia, which is a well-known venue for arbitration. So there, the court acknowledged that enforcement under Sorry. So there, what happened is that there was a set-aside proceeding, and one of the parties said, well, this arbitrator was independent and impartial. I cannot recall the facts in detail for the lack of time, but the court said, well, under national rules, he might as well have been independent or not impartial, but it's international arbitration. We cannot look at lex situs. We would at Colombian law. We have to look somewhere else, and they did look, and they did apply IBA guidelines. So expressly, they said, well, it's international arbitration. I think it was an ICC arbitration. We will look at something more international than just Colombian law. They did apply the IBA guidelines. As I quote, representative of international practices. And they actually mentioned, and that's quite telling again about the stance of the ICC to me, there was an ICC survey showing references to the guidelines in 106 out of 187 cases where an arbitrator was challenged. So, whether you want it or not, I guess even the ICC at some point would have to admit, well, we actually do refer to the guidelines and it's not such a bad thing. But talking about whether it's a good thing or a bad thing.
Excuse me, I just want to clarify the question because it's interesting for me. So, does it mean that if I have, for example, ICC arbitration or LCI arbitration, so is it useless to refer to guidelines, or from these statistics it means that it's not useless? Or they can be just disregarded, and then, so another question, if I, for example, go and then enforce the ICC award in Colombia, in the United States, I can refer to the guidelines, and then, for example, the challenge that was dismissed because ICC decided not to take into account the IBA guidelines can be, for example, refused for enforcement in Colombia on the basis of the IBA guidelines. And if it's useless to refer to the IBA guidelines, what shall I refer to, actually? And so that's the question for all the speakers.
There's a very complex and multi-point question, but I'll try to answer it point by point. So I don't think it's useless to refer to the IBA guidelines. I mean, they're there. They are one of the, if not the most recognized, not a standard, fine, but a guideline, a point of reference when it comes to conflicts. I personally would be surprised if a party read this as the lawyer of the party would not mention the IBA guidelines in a request to have the arbitrator challenged. I mean, simply because these are universal principles, to me at least. At least if it's not the decisive argument, it may well be one of the arguments that you make, saying, look, under any standard you look, this arbitrator is biased or whatever, right? So there's no harm to me in citing them. Whether their application is something that the ICC takes into consideration, again, the official position, and I'm not the ICC, so don't quote me on this, but the official position seemed to be, officially, we don't take them into account. We have our own standards that are not really public. Well, they do have a note, right? They have a note in 2015 or 16. They published a note, I think, on conflicts. But we do have our own standards, but it's not the guidelines. Then again, you read the statistics. They seem to be referring to them at least as, again, a point of reference, not as the decisive element of the case. Whether a domestic court would then set aside or may set aside a award because there is a conflict that the ICC did not consider. I mean, it's an interesting point. I would say, sure, why not? Because I can really not speak on behalf of the Colombian courts. But then you would think that the ICC are quite exhaustive when it comes to conflicts, at least in my mind. When confirming the appointment of an arbitrator, you would have to fill out all the paperwork. And in my personal experience, I'll be honest, if you mention even something that remotely resembles a somewhere between orange and green list issue, most likely you'll get a phone call from the secretariat saying, I mean, sorry, but we would, look somewhere else. So I think that any institution would be overcautious simply because they have the reputation to protect. But I'm not sure I have a clear answer as to whether a domestic court would then use a guideline to set aside an award based on a non-successful challenge application.
Thank you. So it's soft law, but not so soft that so it's useless to refer to it. Actually.
Well, everything's relative.
Yeah,
you know,
okay,
I mean, softness has many.
Any other ideas on this or comments?
So what I was going to say is that in my experience, the IBA guidelines on conflicts of interest are very widely used by everyone in LCIA, ICC arbitrations, and arbitrators appointed by the LCIA do tend to take them into account quite heavily. I had a case recently in which we appointed, so there was the arbitration tribunal, and we decided to add a barrister to our counsel team, and we emailed the tribunal and the LCIA to say we're adding this barrister, but he comes from the same chambers as one of the arbitrators on the tribunal. Now, in England, barristers are very commonly instructed from the same chambers on the opposite sides of the same case, and it's totally, normal. They are completely self-employed. They don't share. They're not a partnership. You can instruct a barrister from the same chambers, but the other side objected on the basis that this situation was listed in the orange list of the guidelines. And the tribunal, so we explained to the other side and to the tribunal that this is completely normal. The two individuals involved hadn't worked together before. There was no reason to even assume any apparent bias or conflict whatsoever. And the tribunal ruled against us and said the IBA guidelines provide a reasonable, and I quote, a reasonable fetter on the party's ability to choose their counsel, and we are going to follow them. And so we weren't allowed to have our barrister. And I think they were worried that they would have a challenge, and they didn't want to. So that's...
Specifically in courts outside of England.
Exactly. So I think that's the kind of situation in practice. And just more generally, it does come up a lot in London because in large law firms where there are different teams, you can instruct the same person as arbitrator from, 5 different people in the same team without even realizing that you've done it, and suddenly you're on the orange list again. So people look at the guidelines for guidance quite a lot, in my experience. Having said that, the attitude of the English court has been quite interesting. There were 2 cases that came out last year in which the guidelines were looked at in some detail. In the first case, the arbitrator was a partner in a law firm. When he was asked to take the appointment, he did a conflict check, and he came up with some kind of minor issues, which he reported. Now, he was a partner in the law firm, but he was a very senior person who didn't attend any partnership meetings or take part in the management of the firm. And he didn't know of this event, which was that one of the parties, the defendant, was owned by a parent company, which also owned another company, which was a client of his firm. And his firm had derived a significant amount of income from this kind of parallel subsidiary company. But he didn't know that. And he'd done his conflict checks, and the conflict checks came clear. His award was challenged by the defendant on this basis, and particularly on the basis that this exact situation is listed in the non-waivable red list in the guidelines, which says that if you are an arbitrator and you and/or your firm is instructed by one of the parties and/or one of its affiliates in the last 3 years and have derived income from them, then you can't accept the appointment. That's what the guidelines say. Now, the addition of and/or your firm and/or your affiliate was added in by the 2014 revisions. the English court found that this was wrong, basically, and instead of applying the guidelines, they applied the English law, common law, apparent bias test, which is the one that you actually set out at the beginning, Sergey, which is that an informed observer, knowing all the circumstances of the case, what would he think? Is there a bias or not? And the judge found that there wasn't, because the arbitrator himself said, if I'd found out this, I would have told them, of course. So the English court, in the nicest possible way, dismissed the guidelines in this case, but in the other case that came out, it went the opposite way. And in the other case, very, very briefly, an arbitrator was appointed by a party who the other party found out halfway through that he'd been appointed several times by that same party. They asked him questions about it, and he refused to answer. He called a hearing of his own motion, and he was quite aggressive to the parties in the hearing. They asked him questions. They said, how many times have you been appointed by the other side, and how much of your income have you got from them? And he just refused to answer those questions. And it turned out that he'd been appointed 25 times in the previous 3 years, and that he derived a third of his income from that same party. So the court said, no, he can't continue. So that's two different cases. But again, the guidelines are helpful in that respect, because they do set out, timescales and how many past appointments you should have as an arbitrator. You have a look at it. If you're in that bracket, then you should at least make a disclosure. Now, one point I wanted to emphasize is that the guidelines say that you should make a disclosure in these situations if you think that that it's not a conflict and that you can act. So it's the opposite of what people perceive it to be. If you make a disclosure, it's just for the purposes of transparency, but for your own purposes, you think you're fine to proceed. So it shouldn't be taken as an invitation for a challenge. And that's all I was going to say. Thanks.
If I can add a couple of comments, I think what Eleni said right at the end, I think that is the crucial takeaway in my view. Disclosure, I think, is the most powerful tool on questions of conflicts of interest, because in any situation, parties engage lawyers to find solutions to win the conflicts and to use the available arguments. And if the conflict argument is available, then it will most likely be used. So you take away that opportunity when an arbitrator provides as much disclosure as they can of possible connections, that and saying that although there may be some interactions, but that doesn't create a conflict in the arbitrator's view. And as long as that is done and the party doesn't object early on, then that, in my view, closes the issue. Obviously, if the party objects at that stage, at least it's early on enough in the case that it still would not have significant financial consequences and can be addressed early on. Just to give an example, I was involved in a case which in the English courts, which is known as A against B and Mr. X, where we challenged an arbitrator for unconscious bias. So we didn't say it was a very respected arbitrator. We didn't say that he consciously was biased. Well, the argument that we were running is that he was unconsciously biased, because at the time when he was writing an award, he was also, as it later came out, as he sort of disclosed when writing the award, that he was also involved with the lawyers acting on the other side on another unrelated matter. I mean, lawyers come up with creative arguments. I mean, in that case, the argument didn't succeed, but it's created some helpful commentary on unconscious bias. And also the arbitrator, later when I was talking to him, said he was very happy because his wife kept calling him Mr. X. He liked that. So in my view, I mean, disclosure is the key. But also today, I think it's important to say that in this room, no one's being told that they have a conflict because of the color of the chair they're sitting on. So everyone on red chairs, relaxed, it's fine.
Thank you. Olga, I think Olga has some story, excuse me.
I just wanted to comment on Elena's experience with LCA tribunals, and they tend to take into account the IBA guidelines. I thought that as well, at least hope so. But we recently had a case with 3 barristers appointed by the LCA, and the claimant at some point decided to appoint a new counsel. And we discovered that an arbitrator nominated by us was instructed by a new counsel on an unrelated case. And now, we approached the arbitrator and the counsel asking to clarify whether he still acts on their behalf. And he confirmed, but there was no disclosure on his behalf. And it was tricky because it was an arbitrator appointed by us, so we decided to object against appointing a new counsel, which we did. And our surprise then was even bigger, just because the whole tribunal said that's not a problem. He's impartial. Yes, he's instructed by a new counsel on another case, so what? And any reference to the IBA guidelines, which actually says it's a red list, did not help. So basically we're in the situation you either take it or challenge your own arbitrator. And then the new counsel was just appointed and we gave up.
It's very interesting. It completely depends on the tribunal you've got.
Well, Venezuela, I think, is known for challenging, to the best of my knowledge, even their own arbitrators quite regularly in ICSID. So, I mean...
Looking to me?
No.
You're talking to me?
No.
I'm counsel to Venezuela in 15 cases. And I was about to say, talking about how institutions, you said something very interesting, a respect of one would expect of the rules and the guidelines out there, because their own reputation is at stake. I was counsel in the first case, it was a Venezuelan case, where ICSID actually accepted a challenge. The year was 2013. ICSID, the Washington Convention was entered into the 18th of March, 1965. And for the first time in that case, the ICSID Secretary General, actually the President of the Administrative Council of ICSID, accepted the first challenge in the history of ICSID arbitration. Later on, very recently, Venezuelan cases also, a number of annulment committees were constituted, and the same person was appointed to chair 4 different committees. They were the first 4 times that person was sitting in an annulment committee in ICSID arbitration. In the context of annulment, of course, ICSID has a vested interest because it's their award that either remains in place or is annulled. So when Venezuela argued that the appointments were being made in breach of what any party could reasonably do in the context of appointment of arbitrators, because these 4 appointments had happened in 18 months. And so eventually, this same person also made a publication in the press in his own home country, speaking about the risks of Venezuelization of his own judiciary, where he was sitting as a member of 4 different annulment committees that were discussing whether or not, among different things, the Venezuelan judiciary was or was not acting in compliance with international obligations. And so this arbitrator was challenged in the different cases that he was acting in. As you mentioned, the challenge in ICSID arbitration goes primarily to co-arbitrators, except where multiple arbitrators are challenged at the same time. So while the challenges were and still are pending before ICSID committees, because of these statements that this person had made, and because of the fact that the same person had been appointed by ICSID more than 3 times in the period of less than 18 months, ICSID appointed him again 10 days ago to chair yet another committee hearing a Venezuelan decision. Just to conclude that this in itself doesn't mean anything. In one of the 4 cases, 24 hours ago, the committee chaired by this person actually agreed with Venezuela in what the result of the annulment should be. So that is, I think, in that particular case, ICSID's interests were aligned with those of Venezuela because Venezuela was defending the award and not challenging the award. But still, the statistical case is out there for commentary.
Well, I just want to mention a couple of few points. The Venezuelan case you mentioned, I know very well because we used it in the second case in the exit history that also was successful in challenging the arbitrator. So we used your first step to take our second step. So that was a very interesting case against Kazakhstan in ICSID, where the issue at stake was actually something that is somewhat discussed, but not, I think, enough discussed, which is issue conflict. It's pretty straightforward, as you would think. When an arbitrator has already decided or published, more of a decided on a point of law, right? But in ICSID, this is quite a big issue because contrary to commercial arbitration where issues are varied and decisions are not really public, ICSID would have, investment arbitration would have a rather narrow set of legal questions, whether it's expropriation or not, what is the scope of the MFN clause, I mean, all the usual stuff. So when an arbitrator would, already render certain decisions, interpreting certain BITs or other instruments in a certain way, then of course this might create a parent bias, call it as you wish. But that case was interesting because, I mean, we all know that certain arbitrators are appointed more than others, and some much more than others for states. May also happen for investors, but I mean, there are a number of arbitrators that are well known for being appointed, for states, sort of carrying on, not this agenda, but just, having their views as to what investment arbitration should be, which I guess is perfectly fine. But then the issue is, well, where is that line between having your informed views about generally the system of investment protection and having prejudged a very specific issue? And so the second case that was sort of piggybacked on the first one that you successfully achieved was precisely about that, because it was yet another investment arbitration brought by essentially the same claimants, or a family of claimants, if you wish, against the very same state under the same legal instrument. And in the first arbitration, the jurisdiction was denied, so it was a negative decision on jurisdiction. The second arbitration, claimants were very similar. The facts were, by the way, very, very close, if not identical, and one of the legal instruments used as the basis for jurisdiction was the same. So the respondent state appointed the same arbitrator in the second proceeding, and we acted for claimants. Then we were confronted with a situation where we know for a fact that there's one member of the tribunal who has already decided that this particular jurisdictional clause in this particular case, based on exactly the same facts, would not work. So, I mean, it was a lengthy exchange, and the results are public, but basically two members of the same tribunal said, we understand there's no apparent bias, and we're not saying that this arbitrator is biased, but it's just, it looks sketchy, weird, call it as you wish, that he would look at the exact same facts, and he would come to whatever the conclusion may be. So it's rare. I mean, I'm not sure whether there are statistics to compare, the proportion of commercial investment arbitrations where challenges are successful. But I guess in investment arbitration, first of all, the stakes are different, and that's actually quite interesting because I've read those views that, well, in investment arbitration, the standards should be even higher, simply because it's a public profile, and you have to explain a decision to the people in a lot of cases. So maybe the standards on disclosure, conflicts, whatever, should be more sort of adapted towards the layman who at the end of the day may read about a given ICSID award in a newspaper or a blog or whatever, to say, well, look, this is weird because this guy was appointed 20 times or this woman was appointed 20 times by this. So, I mean, maybe, and that's again a point to discuss, standards for disclosure should be different in investment arbitration than they are in commercial arbitration. I guess I'll stop there.
Thank you, Sergey. So I think that, like, small conclusion about the IBA guidelines on conflict of interest, that they are rather alive, rather popular. So they're being used in different ways, but it's the soft law. So that's why I think it's being applied how it is applied. And I would like to ask Olga Tsvetkova to briefly comment on the Russian perspective, because we have a comparative perspective seminar about Russia. Because I think in Russia we moved a little bit further in the context of the reform too, that the law provides that the arbitral institutions shall refer in their rules to some particular conflict of interest rules. So in this situation, I think it's a good idea, because in order to promote best standards and best practices in challenging fighting conflict of interest, I think maybe it's a good idea. So it would be interesting to listen about the Russian perspective, and then I would like to ask you to move straight forward to IBA rules on taking of evidence as another rather popular instrument, because so it's another document that we'll discuss. However, we have already almost moved to the treaty-based investor-state arbitrators arbitration topic, but we have it in the end, and so let's move step by step. So Olga, thank you. Yeah.
So as Andrei told, the Russian arbitration law, which we still call new, says that arbitration rules must contain applicable rules of impartiality and independence of arbitrators, providing for requirements for ensuring impartiality and independence. So arguably, based on that position, we can say that every arbitration institute in Russia shall either develop its own rules or refer to any existing one. So it's not enough for the arbitration rules to say just an arbitrator must be independent, impartial, and must disclose any circumstances. The most probably known tool in that sense in Russia is the rules on impartiality and independence adopted by the Chamber of Commerce and Industry in 2010. There is no, let's say, widely known statistics as to how they're applied and whether they are really, let's say, extensively applied. But I think the latest developments of the legislation would make them more applicable. For instance, if you look at the arbitration rules of the Institute of the Center of the Modern Arbitration Institute, it says explicitly that arbitrators must comply with those rules. So, and here is an interesting question. And I should say that actually those rules are generally in line with the IBA guidelines. Though there are some differences. For instance, they don't contain division between waivable red list and non-waivable. And it's also a question whether parties can agree to waive their right under red list. But the most, let's say, interesting question for me is that usually when we speak about guidelines on conflict of interest, we speak about soft law. And in the new context of our legislation and regulation as it is now in the Arbitration Center, is it soft law? I would say no. It was transferred somehow to hard rules, and it may be very important for everyone arbitrating in Russia to understand that we have, or like every arbitration institution has its own standards that may be quite different from the IBA guidelines, and they are hard norms, so you must comply with them. That's from Russian perspective.
Yeah. Thank you. Do we have any questions on this conflict of interest issues? Okay, so then I suggest to move to the rules on taking evidence, which is also very interesting.
I'll try to be brief. Okay. So I would like to start with the proposition that in matters of evidence, soft law may be most powerful. The outcome of which case depends on your evidence. And in that sense, the issues of the evidence may be said to be the most substantive issues in the arbitration. But it's tricky because at the same time, the taking of evidence is a procedural issue. And there is a consensus that all procedural issues shall be left to parties and to arbitrators to decide on. So basically, now both national laws and arbitration rules say that arbitrators and parties can conduct proceedings as they consider appropriate. The problem is that when it comes to evidence, appropriate may mean very different things for lawyers coming from different jurisdictions. And much was said, and I'm not going to go into details about distinctions between adversarial process and inquisitorial process, the former more common for common law countries and the later for civil law countries with a more active role of a judge. But to make it short, in practice, that may mean very substantial differences in how you conduct arbitration. For instance, a Russian client inexperienced in arbitration, or even a Russian lawyer who comes to arbitration from litigation perspective, would never expect any disclosure, and would least expect any disclosure of materials against his position. So soft law may thus be of great importance for developing rules that could, to some extent at least, accommodate everyone and give some guidelines as to what parties can expect from arbitrations. And the IBA rules on the taking of evidence became, I think, the most successful tool, soft law tool, that tried to build common ground between different legal cultures. A brief on their history: it started in 1983, when the IBA adopted its supplemental rules on evidence. They did not gain much success. It's said that probably the arbitration community was not ready for such developments back then. In 2010, the IBA working group, let's say, supplemented the previous rules with the rules as we know them now on the taking of evidence, and they became very, very successful. And the latest revision was in 2010. So now we usually refer to 2010 revision. Coming to how they perceived in practice, I think it's interesting to rely on the report, which everyone can read online. It's a 2016 IBA report on the reception of its soft law tools. It gives you statistics, it gives you some, let's say, understanding how their tools work. As for IBA rules on taking of evidence, about half of all known arbitrations globally, as was reported, refer to those rules. And this is very impressive for a soft law tool, I think. Again, the report says it's especially popular in arbitration jurisdictions which we say are, let's say, most recognized, like US, Singapore, England, France, Switzerland. What is very interesting for us as Russian lawyers, when Russian case law was discussed, no references were found to the IBA guideline, to the IBA rules. And I would really like to know your opinion. Why is it? Because, well, the IBA report has some considerations on that, but I'm not sure they reflect the reality. What's also interesting, in 80% of all proceedings, IBA rules were used as non-binding guidelines. And strikingly, in 90% of all of them, so almost in every case, arbitrators followed them as a non-binding rules. I personally just saw probably once or twice in arbitration clauses references to IBA rules on taking evidence. So I don't think it's a matter of contractual provisions. It's more like really a reputation and probably usefulness of reference to them. They may be particularly useful in some areas which are hardly regulated by something else. For instance, admissibility of evidence. Nowadays, we take for granted many things, like that arbitrators can exclude any evidence they consider inappropriate. But for instance, if you read publications back into 1980s, there was a huge discussion where the arbitrators have right or power to exclude any evidence on their motion, on their own motion. So it's not that obvious as we think it is now. The same is with the disclosure. And the IBO report, again, the statistics show that most cited articles is Article 3, which talks about admissibility, about disclosure, and Article 9, which talks about admissibility of evidence. So you can see that the less some area is regulated, the more probably popular it is to refer to the IBO rules in that sense. I mean, that sounds reasonable and logical. Turning about state courts. The IBO rules seems to be not influential for them. The IBO report found some references by courts, especially it was in common law countries where judges used standards under the IBA to, or parties refer to them, to show that the standard of disclosure is different. So when it comes to annulment, you can show that there is no such wide scope of disclosure under the IBA rules. But in general, courts usually do not refer to them. And I think it's also explicable because evidentiary matters are usually left for arbitrators to decide. And if the court is going to reconsider them, it will go into substance. So I don't think it's there is much need for the courts to refer, but probably some one of you have different perspective or experience. It would be really interesting to see it. So what's the main points of criticism? As with all instruments, there is a criticism. The main point, which is applicable to any soft law rule, is that it's loss of flexibility of arbitration. So don't regulate what can be left to discretion of parties and arbitrators. Don't go into much details because otherwise it becomes more like litigation than like arbitration. And the general question here, are specific rules really harmful? Well, I think that parties do expect ordered and predictable proceedings, even in arbitration, and no one wants a lottery. And I'm sure that most of you faced a client who wanted to make a decision whether to go to arbitration or not, and clients do want to understand what they can expect, even in general terms. Not just there will be an arbitrator and we will plead your case, and it will go somehow. So they do want, and this is connected to the second point, that the more understanding of their rights parties have, the more they will perceive proceedings as fair. Because when you can refer to some rules or guidelines, the parties will understand that it's something regular. It's not just out of nothing, some procedure that they never faced in their local courts. Another issue is whether soft law limits arbitral autonomy. In case of the IBO rules on taking of evidence, I think the answer is no, just because the IBO rules say themselves, they just provide general best practices, minimum standard, and parties are free to rewrite them, refer to only part of them, or just ignore them. And I would say that arguably the rules, to the opposite, widen our national views of what procedures we are accustomed to in our own jurisdictions. So it's helpful in the sense that you understand that the world is bigger and you have just more options available. The second major point of criticism is that IBO rules have been closer to common law, still to common law procedures, and promote US style of disclosure, offer tools uncommon for civil law countries, like extensive witness cross-examination, and etc. We all know it. Under the IBO report, statistics showed that no difference in use by practitioners from common and civil law countries, which is interesting. So we cannot say that practitioners from common law countries like the rules more, at least according to the IBO report.
We'll ask them.
Yeah, so let's ask them. And it's also important to remember that the rules is a compromise. So there cannot be a universal ideal solution. And what can be perceived by Russian lawyers as a very wide scope disclosure, for English lawyers may be perceived as too limited. So you always are looking for a middle ground. But to be honest, the only recent case I came across in my practice where the party said we don't need disclosure was an LCIA arbitration, and there was an English counsel approaching us, a Russian counsel, saying, well, guys, let's avoid it. It's costly, we don't need it, so let's just go. So it's also interesting, right? We say that it's English lawyers and US lawyers who need those procedures, but they just, I mean, and it also shows how flexible it is. You just tailor your procedures depending on your case. But it's still true that hardly any international arbitration avoids disclosure, and that not everyone likes it. And if you had bad experience with the disclosure, you would say that it's costly and time-consuming, and efficiency is low. So usually no smoking gun, doubtful effectiveness of witnesses, party-appointed experts can act as party counsel, basically. I'm finished. So it depends on your experience. Still, the IBO rules do not limit you in that. And I also know that there are regional initiatives in Russia as well to create an alternative tool, soft law tools, which are probably could be probably more useful for parties when both parties come from civil law background and really do not need disclosure, vast cross-examination, etc. And that may be helpful. Why not? But still, to wrap it up, for international arbitrations, I think the IBO rules manage to provide a good compromise, and their application probably will become bigger and bigger.
Thank you, Olga. So now I would like to ask colleagues from common law jurisdictions, Artem and Eleni, first of all, and others are also free to comment. So do you really like these rules as lawyers from common law jurisdictions, and do you think that we in Russia shall have our own rules, like, for example, on conflict of interest, or we shall also use these rules on taking evidence, IBA ones?
Well, I think as lawyers, we generally love rules. And I think that's really important, because then if you know the rules and if everyone's playing by the same rules, you know how the game will work. And I think that's a very important point. And if we look at, for example, in England, if you look at litigation, we have the civil procedurals, this massive book with details and details and details of how the procedure of litigation should work. If we look at arbitration, we have the Arbitration Act, which is a relatively short piece of legislation, and that provides the skeleton of the procedure. You then have the option of picking institutional rules to add on top of it, and usually you go LCIA, ICC, or UNCITRAL, or one of the other institutions. And then rules like soft law, like what we've been discussing today, I think these focus on specific areas of procedure and add additional components to them. So I think it's together, those elements work really well and provide certainty on how the procedure of a particular case will work. I'm not saying you need disclosure of evidence everywhere, but the rules of evidence don't deal with documents alone. They deal with witnesses, they deal with experts, and in my view, they are a definite advantage and they provide certainty. And I think this is supported not just by the statistics that Olga has quoted, but if we look at the Queen Mary University of London survey, so in 2012, it said that these rules, the rules of evidence, were used in 60% of arbitrations. And if we look at the 2015 survey, 90% of those surveyed were aware or had used the rules of evidence in their arbitrations. So it's a widespread used document, and I would like to quote Sergey, who said it's the default position. And I think I would have some sympathy with that. That doesn't mean there isn't space for an alternative set of rules, and Olga's mentioned the Prague rules, which are being discussed in their in their conception stage. And personally, I think if those are well prepared and thought out and provide a true alternative, then lawyers can look at a particular situation and decide what to apply in that particular case. And it doesn't always necessarily have to be the IBA rules of evidence, but at the moment there are no true alternatives to provide structure, particularly for international battles where lawyers come from different backgrounds and are used to different things. So you need a unified set of rules for that particular dispute. Another reason why they're particularly important in common law jurisdictions is going back to the litigation experience. And we've already mentioned earlier today cases where you have 3 barristers sitting as arbitrators. So those barristers probably do bulk of their work doing litigation work. So they're used to the civil procedure disclosure, where you have to disclose everything, including everything adverse to your position, which is relevant to the case. So the risk a party faces that if parties don't agree, say, on the IBA rules of evidence, they potentially face the risk that 3 arbitrators, 3 barristers go, all parties haven't agreed of anything, we're used to disclose like in litigation, this is not litigation, but why not, let's apply those principles as well. So there is a risk. Obviously there's a risk of also, if you've not agreed to anything, that they might decide there'll be no disclosure. Unlikely to happen, although there are examples. And then 2 more things that I want to say. The first of which is that the most likely place, yes, you probably wouldn't see a reference to the rules of evidence in dispute resolution agreements, in the clauses in the agreements, although I've seen on occasion it to be mentioned there. But the place where I see it mentioned most often is the first procedural order. So once the tribunal is appointed, they need to set out the procedure, and usually this is where the rules of evidence get mentioned. I don't know if the other speakers have similar or different experience. And the final point, technology. So there are a lot of apps available with a lot of helpful soft law documents, including, I've just recently found out, the IBA Arbitration Handbook. So a small plug for them. It has all their rules in all the different languages available on the app, so you can always have the rules with you, including the guidance on conflicts and all their various other publications. So keep an eye out on that, so you have everything that you need to hand.
I'll just add some experience to that. First of all, I agree, Artem, to your last point that you very rarely see reference to the IBA rules on taking of evidence in the arbitration agreement itself, but you very frequently see it in the first procedural order, and that's where it goes. Now, I agree that the whole beauty of arbitration is flexibility, and you have to take charge of your case at the beginning and decide how you want the procedure to be managed. And you could decide that no disclosure is necessary, and it's happened to, I've done that before in cases. But if you decide that disclosure is necessary, and I will talk mostly about disclosure because that's the most widely used part of the rules, the option of using the IBA rules on the taking of evidence is in my experience, by far the most preferable option in international arbitrations. I can see what you say about if you have 2 civil law parties, then why would you even go there? But if not, and even if you have 2 common law parties, I would prefer that to the standard disclosure that Artem mentioned. And if you have a common law and a civil law party, then that's the best thing to go. Just to give an example of a practical experience, what you prepare as a result of disclosure pursuant to these rules is what's called a Redfern schedule. And in my experience, they can be quite cumbersome and difficult, and you end up hating it by the time you've finished it. But they do make parties focus on the issues right at the beginning. So I think that's a good thing. If you have 2 different jurisdictions on either side, then everyone is unhappy with the other side because of the way they've treated it. So in one of my cases, for example, I was acting for the defendant, and there was a claimant who had a US law firm instructed. When it came to document production, we prepared a list of 5 requests for documents. We were faced with a list of 80 requests for documents on the other side. So that just was very difficult to deal with. And I could see that, from the US perspective, it's perfectly normal for them to kind of do this exercise. And in fact, when faced with the documents that came through, as a result of our 5 requests, which were all allowed by the tribunal after vigorous objection from the other side, we got thousands of documents. So it didn't resolve the issue of disclosure being extremely expensive and cumbersome. But I do think that if we'd had standard disclosure or if we'd had kind of US discovery, it would have been worse. So that's all I was really going to say. I've got another case which is a bit different, which I was going to mention very briefly. In another case, I'm acting for the agent under a contract who is entitled to commission under the contract and wants to claim commission for work introduced to the principal. And we've asked for the documents proving what introductions he's made from the principal. And we got a reply saying that the IBA rules on the taking of evidence do not allow fishing expeditions. So we are going to make an application to say that this is actually nothing to do with the IBA rules on the taking of evidence. But you see them being used as a defense or as a tool to resist disclosure of documents. That's all I was going to say.
Thank you, Eleni. So we see that everyone is pretty much satisfied with these rules. Do we have among the speakers someone who doesn't like these rules? Maybe among, I don't know, participants?
I can speak. I know people who hasn't liked the rules. It wasn't me. I was an arbitrator, for instance. Mm-hmm. And I will start by the proposition that the bridge that the IBA rules actually builds is not so much between civil law and common law practitioners, but between arbitration and non-arbitration practitioners. And I'm born, raised, but also legally trained and practiced in Argentina for 15 years before moving to Miami, which is very close to the US. Not quite there, but very close to the United States. And I was appointed the sole arbitrator in an ICC case, seated in Miami. And it was argued by 2 absolutely 125% US litigators. And so I drafted Procedural the number 1, and we told the parties that we would adopt the IBA rules. And the whole of the proceeding went forward, and there were requests for production of documents that were probably more devised and followed in light of what would have happened in US litigation. And during the hearing on the merits, right before the respondent party started with its closing arguments, we had a coffee break, and as I come back from the coffee break, I find a folder on top of my desk. So I go onto the record, I say, the first thing I want to know is that there is a folder on my desk that wasn't there when I left for coffee. I don't know what that is, and I'm not opening it until someone tells me what it is. So counsel for respondent says, that is the law. I said, what do you mean? Pause again. The law. He said, well, if I didn't give you the law, you would try and get the law somewhere else. So I'd rather hand it to you. I said, but this is something that is already regulated in Procedural number 1. And I went to Procedural number 1. There's a reference there to all legal authorities being included with the submissions and nothing after the submissions. And we had a very strange discussion as to what legal authorities were. 9 months after Procedural number 1 had come into place, because no one had paid any attention to what was meant by the incorporation of the IBA rules. Now, that is not exclusive of common law lawyers. I was appointed the chair of 3 related proceedings in Peru, for a local center of arbitration in Peru. There's a massive amount of arbitration in Peru for those who don't have these anecdotes in their minds. For some strange reason, the public law, public contracts procurement law in Peru calls for mandatory obligation. Every contract with any Peruvian government agency for $5,000 or $5 billion has to go to arbitration. But it has to be arbitration before a center located in Peru, which doesn't mean that all arbitrators have to be Peruvians. On one occasion, I was appointed chair of a local Peruvian institution set of 3 arbitrations. And procedure number 1, we put there the reference, as Lenny was saying, to the fact that we would entertain reference schedules for the exchange of requests and production of documents. Following day, one of the parties wrote to the institution. He didn't challenge me as much as complained that the incorporation of foreign arbitrators into the panel had resulted in an abuse of modernities and eccentricities, like inviting this reference person. So it's not so much an issue of whether this is a common law or a civil law background, but more of whether we are dealing with arbitration practitioners or non-arbitration practitioners. And I think that things like the IBA rules are particularly useful when only one of the parties is versed in national arbitration, is used to the toolset, and the other one is not. It provides a very good backdrop, this, as counsel but also as an arbitrator, to show the party that is not used to national arbitration that you're not just making this up, that this has been done very regularly by thousands of people in hundreds of places in 90% of international arbitration. So that, I think, provides a background and provides some reliability on the tool being used.
Thank you very much. Colleagues, do we have any questions? Oh, yeah, we have a question. Yeah.
Thank you very much, Sergey Morozov, Baizenborg, Moscow. So I actually have a question to all of you, maybe, because I think we should distinguish 2 sides of any rules of evidence. Looking, for example, at the United States, we have the Federal Rules of Evidence, which regulate the evaluation, the process of examining the evidence. For example, lots of rules for character evidence and inadmissible evidence, for example, hearsay. And the aim of this part of rules of evidence is to protect the fact finder, the jury, from bad evidence, inadmissible evidence, like once a criminal, always a criminal. And we have another side of procedural evidence rules, like Federal Rules of Civil Procedure, which regulate the issues of disclosures, number of requests for admission, for production of documents, and so on and so forth. In case of IB rules on taking of evidence, we have the second part, basically taking of evidence, not examining. We don't have lots of issues related to the how to examine what witness had said in the proceedings. And don't you think that in this case, IBA actually interfered and occupied the field which they were not authorized to occupy, meaning that in lots of arbitrations, these rules are some kind of default rules. So parties basically refer to them as they're not making up their own new rules. And by these practices, and as we know, the creators of these rules were mostly from common law jurisdictions, we have more and more common law approaches. So we reduce actually the autonomy of the parties on regulating these issues, because they already have, this example, and they are actually psychologically biased, always looking for this example. Because we have other examples, other issues of regulating some procedures. For example, our colleagues from Debbie Voice and Plimpton recently updated, I think, 2 handbooks on arbitration clauses and I think efficiency in proceedings. And for example, these documents are not taken into account as some kind of guidelines, some official guidelines and default rules. So don't you think that IBA was pretty smart in this move, or it's okay just some kind of purpose to educate the parties and not to protect the fact finder arbitrators because they're by default well educated and smart?
Colleagues, who would like to answer?
Well, I think the rules you mentioned at the start of your question or comment, they apply to litigation, so I think they should be ignored for purposes of arbitration because these are 2 very different fields. So that's the starting point. Then when we get into arbitration, it's a consensual dispute resolution mechanism where parties are free to agree the precise procedure for every specific dispute. So even though the IBA rules of evidence are the most widely known and the most widely used, I think the parties still have an option not to agree and put forward their arguments for doing so and suggest alternatives if they are able to. If parties are unable to agree between them, this is an issue that the tribunal will have to decide and resolve. So I think, which is once again in accordance with the agreement of the parties, that the tribunal reaches these decisions. So I think, as I say, personally, I'm open to there being alternatives, which would be provide other ways of dealing with evidence or documents. But one thing that's very, very important is that we shouldn't be using litigation rules for arbitration. I feel very strongly about that. And second, parties are free to agree in arbitration if they agree on the IBA rules. Then that's their agreement.
Thank you for the question. For the answer, we have another question from the audience.
Hello, my name is Svetlana Popova, Rosneft. I have a quite practical question. I really was interested in the situation, I think, discussed by Eleni when the council was, the new council that was changed in the middle of the process, the arbitrator had a conflict with him. Is it the only case you know about, or is it a general approach that should be given to such type of situations? Because it looks like a party make a certain pressure on the other party to change the arbitrator rather than they change their counsel to one that is not conflicted. So I think that something like that can also happen with not only with a representative in the case, but also with an expert that could be conflicted with an arbitrator. And as we know, the expert is chosen when the tribunal is already formed. So we heard what is the position of the LCA in this case, and what would be a general approach of arbitrators in other institutions under other rules. Thank you.
So I think it depends how far along the process you are to find the answer. In my case, actually, it was right at the beginning that we were just adding a barrister to a team of 2 solicitors. So there was no question who was going to go. and usually you would not remove an arbitrator. You know, that would really be, if you are appointing an expert, then it's up to him in his instructions to say whether he thinks he might be in conflict with your tribunal. And if you're appointing a barrister or you're appointing somebody else, they need to say, and if they don't, then the tribunal will need to say pretty much straight away whether they think that there might be an apparent bias or not. I think it does happen. You know, it happens more frequently than we realize, and we don't realize only because it's not in the judgments, because the situation is resolved pretty much early on, you know, at the beginning, you know, preferably. I mean, I know about some investment treaty cases where there was a challenge to an arbitrator right before the hearing, and they had to start right from the beginning. I mean, you can't do that. Actually, I had a case in an investment treaty case, in which we had the final hearing before a tribunal of 3 arbitrators before Christmas, involving cross-examination of 6 witnesses on each side, 3 experts on each side. The tribunal went away to write their award, and suddenly this email popped up from one of the arbitrators resigning. What is going on? And you don't know whether they suddenly think, oh, you know, I might be in conflict. You don't know. You have to, you know, start assuming things. But thankfully, we managed to get the arbitrator reinstated, because also the other side didn't want them to resign, because we would have had to do a whole new hearing. So that was a good result. But, you know, this question about conflict and apparent bias is quite subjective, and it's a lot of it is to do with what you think yourself rather than what other people think.
Thank you for the question, for the answer. So I suggest to move. We have another question? No? Okay. I suggest to move further to another IBA document, which is IBA Guidelines on Party Representation. So as far as I understand, it's a rather new document compared to others. In the report, it's referred as not so popular because in the opinion of some people, it doesn't fill in some kind of gap, like in case of conflict of interest or taking of evidence. However, from Russian perspective, I think that it's a rather useful document because maybe in some jurisdictions where you have long-standing arbitration traditions, good arbitration culture, I will say, so maybe it's not so useful, but in jurisdictions here, for example, I think it would be rather useful to refer to these rules and to use them more often. So it would be interesting to hear from Diego about these rules.
Thank you very much. And just to start off, the IBA guidelines on party representation actually answer the last question we just heard. And one of the areas which the IBA found that still had not sufficient coverage, or at least sufficiently uniform coverage, was what to do with conflicts of interest that result from, I'll simplify by saying, people getting into the arena at different points in time, and what happens when the person entering last is a lawyer that was chosen perhaps with the absolute purpose of creating a conflict on one of the arbitrators. And I have no statistics on how usual it was that it would be done, but I fear that it was usual enough that someone came up with the idea of regulating it. And just to step back as to why things like the IBA guidelines on party representation are very useful for some limited purpose, and I don't think that it provides a universal remedy for all maladies in the fashion of l'elisir d'amore or anything of the like. But as late as 2010, I was counsel to Argentina in an ICSID case, a very renowned ICSID case, because it had 192,000 claimant parties. And so we got a huge amount of documents in PDFs, and we started realizing the claimants were, by their statements, Italian holders of sovereign debt issued by Argentina. We started looking at the powers of attorney, and we realized that as we started just looking at the papers, many times the signature would have the surname, comma, the name. And that's not how an Italian would sign. That's not how an Argentine would sign. And we looked at 1 and 10 and 100, and at 1,000 we said, let's bring an expert. It simply cannot be. We brought in an expert. We did some random sampling. We found at least 3,000 forged signatures in the powers of attorney out of 192,000 claimants. Now, here's the issue. If we had found 3,000 forged signatures, the owner of the signature would never know that he was a claimant. The person who had put the forged signature could never get the check, because the check would be issued in someone else's name. The one party that would get the check is a lawyer on a contingency arrangement. So we brought the issue before the tribunal's attention, and we said, this is highly irregular, and there is no way that counsel is not involved. And counsel responded that since this was ICSID arbitration, which is completely insulated from the interference of any domestic court system, they were neither bound by the bar rules of where they were licensed, or the deontological rules of where the powers of attorney were issued, and not even by the deontological rules in Washington, which is where we were sitting and having this discussion, because basically ICSID exists about 20 centimeters above the floor of Washington, but not in Washington. That is one of the consequences of ICSID Convention Article 21. So things like a set of rules that would apply to international arbitration by the mere fact that they are in national arbitration do fill in certain existing gaps which can be very, very relevant. They regulate areas which, if you get sufficiently high in the field of international arbitration, by high I mean sufficiently busy and traveling around. This is the second week in February only, and this is the 5th intercontinental flight I took to come to enjoy Moscow, which I hadn't come to in 15 years. So what happens is there's a limited number of people working in huge amounts of cases which involve teams which have, in the last hearing I had, we had counsel from Pakistan and Texas, which is also very close to the United States, and France and Argentina, all working as counsel for one and the other party in a single case. If the rules governing the ethical duties of each of those lawyers to the same 3-member tribunal were different, that could create a certain asymmetry which could be arbitraged against. Not arbitrated, but arbitraged. Some party could benefit from the different exposure to ethical rules that the different lawyers in a team would have. Case in point, a British lawyer is supposed not only train, but conduct a rehearsal of examination. An American lawyer would probably feel that it would be incurring in negligent behavior if it did not rehearse examination with a witness. Maybe it's the same witness. Maybe these two people are co-counsel, and that can be resolved through the client. But what if they're opposing counsel, and the witness for one party comes in and has rehearsed 100 hours with lawyers, and the party to the other party, and the witness for the other party has not rehearsed because of some duty of conduct to the tribunal or some deontological rule. So there is an area where uniform rules governing the conduct of lawyers in a case can be very tranquilizing. And this is one of the areas where the IBA rule says it is not improper for counsel to conduct witness examination, rehearsals, preparation, if the lawyer feels that that suffices for purposes of not breaching its own rules before the bar in which that person is licensed, then that's great. If it does, that lawyer should perhaps step aside and let someone who is not bound by those more straining rules step in and take the case. There is a number of other areas, and at this I will take more an inductive approach than a logical one, which have been identified as things that maybe are not sufficiently otherwise uniformly regulated. First off, the duty to identify yourself as a party representative before the tribunal and before any witness or potential witness. It is not entirely uncommon for someone to be kind of a ghost lawyer behind the scenes of a case on one side or the other. And this may have huge consequences in areas, for instance, of conflicts of interest. What if there is a ghost, open and close inverted commas, lawyer who knows what a particular arbitrator has written or is deciding on a separate case or is advocating for in a case where the arbitrator is part of a legal team? The fact that that person does not disclose the representation of the party may unfairly generate a problem with conflicts of interest. As I was mentioning, the issue of the level of conduct required to have a level ground on the level of participation of lawyers in the preparation or presentation of the evidence. Also, duty of conduct itself, to many of us, including Argentine lawyers, the expression duty of conduct was not something legally relevant in the practice of law. Not saying that it is now, but at least we cannot say that we don't know what that is. Under the IBO rules on party representation, lawyers are supposed not to make knowingly false representations of facts and not to make knowingly unreasonable representations of law. And that is something that in many places simply either is not regulated or is simply permitted or expected of counsel just to present a case as best you can, including incurring the occasional white or otherwise colored lie, just for the purposes of furthering your client's case. Again, this is an area that is specifically covered in the IBA rules. One of the real problems with the IBA guidelines on party representation is precisely that they are not rules. So I have not as yet seen an arbitration agreement or treaty where the language dealing with the rules governing the arbitration include any reference to the IBA rules or guidelines or otherwise regulations on party representation. I was privileged to be, for instance, in Vienna last December at the first session of working group number 3 in UNCITRAL, where there's discussion between states and certain NGOs regarding amendments to the investor-state dispute resolution system. There was a lot of discussion on a number of things. Only the agenda for all the discussion that will take place was laid out, but there was no specific reference to rules governing what is now covered by the IBA guidelines on party representation. That is, we're still not even getting there. So how do you actually make them work for some purpose? And the way the rules are crafted is very intelligent, I would say, in that, of course, as most other sets of guidelines, rules, or regulations, it says if the parties agree to applicability of these guidelines, then they will become applicable. But they have something of a safeguard, which is to say that the tribunals can, after consultation with the parties, also, even if there's no agreement to apply the IBA guidelines, still apply them if they consider that that is required to protect the integrity or the fairness of the proceedings. So that in some way that is aimed at becoming kind of a default rule available to tribunals out there that may think that if no regulation is set which is uniform among all parties involved in a given procedure, then there's a chance that the situation would jeopardize either the integrity of the proceedings or the fairness of the proceedings. And so that is a way that they have found to come to a practical application of the rules. Last section I will touch upon is what the effect of all of these are. And this is also, I think, very, very interesting. The IBA guidelines set a range of consequences coming from breaches of the duties in the representation of parties that start by admonitions, and the legal profession is particularly, in the digital era at least, I think, is particularly susceptible to admonitions. And there was just 2 days ago the fact that a tribunal had admonished a law firm for fraud in the representation of certain evidence regarding a casino dispute made very global news. So there is something in the way that we are currently practicing international arbitration that makes us particularly apt to suffer blemishes from reputation. That is in itself probably the single most useful effects of the IBA guidelines. Also, there is, of course, the adverse inferences that may be drawn against a party's case if its party representatives engage in breaches of conduct. How fair is that to the party? I don't know, but in Latin they call that culpa in eligiendo or culpa in vigilando, so there's that. Eventually, there's also punishing the party rather than counsel, the issue of the effect that breaches of duties of party representatives may have in the allocation of the costs of the proceedings, which should be, I think, the ultimate tool for forcing parties to choose and survey the conduct of their representatives in arbitration. This is an orderly presentation of the several areas that is covered, but this is just an invitation to take questions on any of these areas. Thank you.
Thank you very much. I think the sanctions issue is the most interesting one in this regard. Colleagues, do you have any examples of application of these rules? Or maybe so. Any questions from the audience? Well, I think it's rather interesting, and we have a good perspective in Russia in applying these rules. First of all, we shall somehow regulate legal profession here in order to make it a little bit more united. Yeah. So then, in order to apply sanctions and to try to self-govern somehow this society. So then, in order to follow the timeline, I would like to move to our final question. Maybe you noticed that today a lot of people were talking about the investment arbitrations. I don't know, maybe because they are more transparent. So now I think Nikita will tell us about UNCITRAL rules. So we finally move from IB to a new body, to UNCITRAL, rules on transparency in treaty-based investment state arbitrations. So please tell us whether our speakers actually could tell us more information about investment arbitration or not.
Yeah, I think they've already contributed quite a lot, and a lot of issues that are relevant also for the treaty arbitrations have been raised and discussed. But I think UNCITRAL rules on transparency is probably like one of the recent instruments that has not been yet applied, or that is yet to become more and more frequently applied, hopefully, or not hopefully, that depends on your perspective. And what I would like to do, and what I would like to start with, is that I would like just to give a short overview of why is it relevant and why does it exist, why do those rules exist, and then maybe we could source on very rich experience of our speakers here, and exchange views, because unfortunately, as I've already mentioned, there aren't that many examples of the application of those rules. So evidently, investment arbitration is very, very different in nature from commercial arbitration that we have been just discussing, solely because of the fact that the goals that are pursued by investment arbitration are completely different from commercial arbitration. And if I may put it in very general terms, or at least in my very primitive understanding of what the goals of investment arbitration are, it's basically to put investor and the state more or less on the same level, and to allow them to settle their disputes before a neutral forum in a very depoliticized way. So evidently there's a huge element of public interest, and there are a lot of parties that are interested in the outcome of the dispute, including the taxpayers, including maybe third parties, or even third countries if we're talking about a multilateral treaty being applied by an investment tribunal. So if we look at this from another perspective, those parties may be interested not only in obtaining information about the pending dispute, but also even in some cases participating in the dispute, virtually submitting certain information to the tribunals, or maybe certain evidence, and so on and so forth. But strangely, until recently, only 10% of the existing bilateral investment treaties anyhow touched on the issue of the transparency. That is probably well, I cannot say that it's strange, yeah, but considering the fact that the issue is getting traction these days, it's definitely going to be a hot topic, I think, in the next few years. So that is probably not surprising, because the investment arbitration was in many ways based on the model used in the commercial arbitrations originally. But like if we look, for example, at UNCITRAL rules, and on the original UNCITRAL rules, they are quite restrictive with the access to the information about the awards. If we look at the older versions of the ICSID rules, they may also be quite restrictive. And now, definitely, ICSID is way more transparent than it was before, and the awards are regularly published, and so on and so forth. But definitely, the level of publicity that investment arbitration is facing is not as high as some would like to, and or definitely some states would like to be. So this matter has been brought up in UNCITRAL, or during the discussions of one of the UNCITRAL working groups, and it has been discussed in some ways since the beginning of the 21st century. But the real mandate for the working group to actually come up with an instrument which would regulate this issue has not been obtained until, I think, 2009. So the result of the work of the UNCITRAL working group, I would just cut it short, is sort of twofold. First of all, it's the so-called Mauritius Convention. And second of all, it's also the UNCITRAL rules on transparency, which are the topic of our discussion here. So the mechanics in which the rules are applied are fairly simple. So they provide for so-called passive transparency and active transparency. So what do we mean by passive transparency? Passive transparency is the ability of third parties to receive information about the hearing, to receive documents about the hearing, and those rules, they are very helpful in regulating what information can or should be disclosed by the parties about those hearings. Yeah, and when we talk about active transparency, that's a little bit of a different issue. So then we talk about regulating what parties and on which basis can interfere with the investment treaty proceedings, which is also quite relevant right now, especially in light, for example, of the recent solar arbitrations, which are probably quite common. And in those arbitrations, I think I probably would not be wrong to say that in every second case, or maybe in every case, EU Commission has intervened as amicus curiae with to share with the tribunal its thoughts on the applicable law and how intra-EU bilateral investment treaties should be applied. Yeah, and the rules pursue the goal of limiting the amount of discretion that parties and tribunal are able to exercise in respect of the rules, and they limit in great extent the exceptions. So they limit the discretion of the parties, the discretion of the parties that can be exercised in order to derogate from the rules, and the rules pursuing a very simple goal of setting like a baseline for the transparency. But nobody says that this baseline cannot be kind of like, that parties cannot set higher standards for transparency. And this has actually been the case in one, and I think probably the only one example of the application of those rules, which has been, I think, an exit case in PSG versus Guinea, where parties have actually opted for a higher standard. And this was regulated by the tribunal through a separate procedural order, governing exclusively the issues of transparency. So far, the UNCITRAL rules on regulating transparency should be applicable to all bilateral investment treaties providing for UNCITRAL arbitration, which are entered into after 1st of April 2014. And so far, there has been already quite a mess of those treaties. So in total, I think 41. 4 of those treaties are the treaties entered into by the Russian Federation. And another notable examples, I think, CETA and TPP, which also, as far as I recall, mention those rules. And CETA provides, as far as I recall, even higher standard for transparency. So, but if we take one step back, we will see that the rules have not been excessively applied yet, unfortunately. And it remains to be seen whether those 40 or some over 40 treaties would generate any disputes in the near future where the transparency rules would be applicable, or where parties would choose to apply those rules maybe under different treaties. Very big question is, however, those rules have been available for quite some time now, but apparently not so many parties have chosen to follow those rules. And this is, I think, a question which we could probably pass on to the panel discussion and formulate it in the following way. So, who do you think benefits more from the transparency? Is it the state, the host state, or the investor?
You have?
I mean, yeah, sure, I'm not shy.
We know it.
It's there's no one answer could provide. I've been counsel to a number of states in investment arbitration. I've been counsel to a number of privates in disputes with states, including a lesser number of investment disputes also. And the one thing that I think is common to most disputes is that the minute the scope of the dispute starts falling outside the exclusive hands of the disputing parties, the more difficult it becomes to reach negotiated forms of dispute settlement. So the moment the civil society becomes involved, it's harder to reach agreement on things that could be perceived as waivers of issues of principle, be that it will result in the claimant party or the respondent party being forced to adopt a more stringent position regarding the claim. So a number of states have taken a restrictive approach to issues of transparency concerned with the ultimate goal of reaching dispute settlement. Now, other states have taken stringent approaches to transparency based on other, I would say, very justified concerns, which are basically that the amount of public information on states that privates get access to is numerous times higher than the amount of public information that states can get on their opposing parties' privates, except for filings before regulatory bodies or stock exchanges or whatnot. But there is an inherent imbalance in the information to which the disputing parties can access that could even be further enhanced to the detriment of the state party if not only that particular private, but any private with a wish to create mayhem, and there's a good number of privates with wishes to make mayhem, can access the proceedings as they move forward. And that affects part of what you were calling, quite appropriately, the active form of transparency, the ability of parties, non-litigating parties, to access the proceedings and to request the access to the submissions and to make submissions themselves. It makes the dispute so multiform that it also becomes somewhat haphazard, and that in the end also increases costs, but merely creates an unpredictable result as the outgrowth of transparency. And that's perhaps the 2 cents I would have to comment.
Thank you. Sergey?
I also thought about a very straightforward issue where something appears in the middle of the proceedings out of the blue. I was thinking a corruption allegation that would then be problematic media-wise, PR-wise, for, well, whoever is involved. So corruption is a two-way avenue, so that would be both parties, right? The state and the investor, assuming that Corruption Act was relevant to the investment, which may then lead, either to slow down the proceedings or to inquiries into the motives behind. So this also, you simply don't know at times what kind of documents and information will come out of your document production or by a private investigator that either side decided to hire in the middle of the proceedings. So that's also one of the consideration. I wouldn't say necessarily against transparency, but just something that has to be taken in mind, that sensitive information is not necessarily only commercial secrets, state secrets, etc., but something that may cause a repercussion that would negatively affect the dynamics of the proceedings.
Thank you very much. I think it's a rather sensitive issue, maybe a little bit political issue, not only legal issue, and it would be very interesting to look how these new rules will be applied, how they will be developed. Thank you very much, Nikita, for telling and for the colleagues for commenting on this. Although I think these rules are not actually maybe the example of classic soft law, because as far as I understand, being the part of Mauritius Convention, it's sometimes can be looked like kind of part of the rules, arbitration rules.
Well, they're technically part of UNCITRAL rules
Yeah.
because there's explicit reference in the 2013 version to the transparency rules, which states that they shall be applied to all the treaty-based arbitrations after 2014, and there is also opt-in mechanism which allows the parties to agree on using the rules. But as we can see, so far there aren't plenty examples of the parties agreeing to that. Yeah.
I think the Mauritius Convention was signed by 18 countries already, and then 3 countries have actually also ratified it, and I think that's what you need for it to be
Effective.
actually mandatory, the ratification.
Yeah. So it's already effective, I think, from October. But
Yeah.
again, only three parties have ratified it. So
Very interesting that one of the 3 parties includes Switzerland, though.
So that makes
much for transparency.
So that makes it a little bit more than soft law, but still, so we have here UNCITRAL as a kind of a new body that deals with soft law, and I think that we don't have, unfortunately, more time to discuss, but the thing that we can think further and maybe discuss further is whether generally the soft law drafting actually needs some kind of changes, because we have IBA, like already rather successful platform for discussing soft law and for working on it, but we also have UNCITRAL, we also have ECA, which has some task force, for example, for the third-party funding report that we recently had and discussed during our previous seminar. We have some initiatives coming from arbitral institutions, which are not so active, for example, in IBA. For example, recent initiative of SIC, Singapore International Arbitration Center, on cross-institutional consolidation of arbitrations. So maybe we will need, or the institutions can discuss among each other some kind of a new platform for developing some soft law regulations that will more involve arbitral institutions in drafting these rules and discussing these rules, and that may be more actively applied by arbitral institutions to make it more unified. So I think it's also an interesting way of development that we can discuss. Thank you very much, all the speakers. I think the discussion was very interesting. Thank you very much to all the participants for attention, for questions. I would like to thank our partners for this event, the International and Comparative Law Research Center, who host this event, Legal Forum Academy, also our partner of this event, and I would like to say that this seminar was recorded and it will be available on our YouTube video.
Very transparent.
Yeah, very transparent, yes. And so you can share it with your colleagues, or if you want to hear one more time on some specific issues, if you have arbitrations and you need some advice from the very professional speakers, so you can listen to it one more time. Thank you very much, and I encourage everyone to have to discuss questions during some networking that we'll have now for about 30 minutes. So thank you very much. Thank you.